one of the chronic complaints about the Human Rights Commission from my early time, I had occasion to do all the legal work for the Human Rights Commission a number of years ago. And even back then, when things were much different in Alberta, we still had a large inventory. Currently, if you look at the current annual report and the most recent annual report of the Commission, there's still a large inventory. The number of touches on a file is, in my view, extreme. It takes far too long. You mentioned that it taking five years to get matters resolved at the tribunal level. That's not exactly access to justice. Data is valuable, of course. Numbers are valuable, but we have to look behind those numbers. And who's affected? Well, first of all, over 75% of the complaints that the Commission gets are in relation to employment. The remainder are accommodation and services customarily available to the public. And a lot of those service complaints are complaints against the government, quite frankly, because they provide a lot of services, right? And the concern is individual employees and very often small employers. And I appreciate that's a burden on business having to deal with a complaint. Prima facie test for discrimination, which is the first gatekeeping at the Commission. That is to say, on the face of it, is this complaint got merit? That's really what the test is. And if it does, then there's got to be a way to expedite these things. I read two recent decisions from the Commission, from the tribunal. One related to a complaint that originated in 2013, and the decision was in 2020. And another was a decision in a complaint in 2014, decided in 2022. Like, that's unconscionable. That really is unconscionable. If the director is going to have essentially unfettered discretion to dispose of complaints, I think that's dangerous, because if it becomes a matter of inventory control, that with respect, we don't get complaints from individuals who are well-heeled. It's usually the marginalized population. It's usually the people that are working in low-paying jobs. It's often people that are disadvantaged in many other ways. And this is the only game in town. The common law does not, as far back as 1981, Chief Justice Laskin, in a case called Seneca College, said there's no common law tort of discrimination. So you can't sue for it. So if you've been discriminated against, you have to go to the Commission. And I think it's dangerous. And we can have people with the greatest of intentions and integrity, but I think it's dangerous to say, I can dismiss this complaint. The civil standard that applies in human rights matters is, of course, on the balance of probabilities. And in the criminal law, we often say, Crowns will come into court and say to the judge, we're withdrawing this charge because there is no likelihood of conviction. That's a pretty high that's a very high bar, because it's the criminal bar, right? It's the beyond a reasonable doubt. I'm reluctant to give that much authority to one person, and quite frankly, I'm not convinced that it will reduce red tape. I mean, I think this is just they've just wrapped this up with red tape to make it look good, but I don't see the problem, quite frankly, that they were trying to solve.
All of these changes are what I would refer to from my professor, Lawrence Lawson, who's now a Ontario Court of Justice. I think he's on the appeal court now, but he used a phrase when I was doing my master's that I think is very appropriate to anyone listening. There's something called bureaucratic disentitlement, which I think Nam and Bob have both pointed out in terms of how changes to any statute, which then tends to take away the rights and access to justice and any of the fulsome adjudication that you would hope that we would try to achieve in human rights. So I can tell you one thing, but I mean, change is necessary, and that the problem is that especially in Alberta, we do these tweaks, and we're hoping that somehow we're going to better serve the people, but I'm not sure if it's ever going to even come close to being something that's even geared towards trying to help, even large issues, small issues. So when we talk about these changes, whether it's to take out the statutory appeal provisions or to try to give more power to the director, add a new deputy director role, so a role of delegation, all of these things, I can say, look, I can look at them neutrally. What really is really important is how then does the institution tackle the larger problem. On behalf of the John Humphreys, I wrote a book with my former colleague, or I wrote a chapter for the book that John Humphreys published, where we really looked at the history of human rights and tried to make sure that we understand that, look, as an institution, the Alberta Human Rights Commission, as well as the tribunal, they have very limited resources to try to achieve certain results. So to Nam's point that, well, look, I mean, here's what they say they're attempting to do or they're going to do. Whether or not they actually achieve it is something that I think all of us have to be able to have a venue to voice our opinion on. Are we achieving? Like, from a timeline, forget it. They're completely off base. But you mean they have now support from the Supreme Court of Canada that says that there's no constitutional right to have an administrative hearing in a reasonable period of time. So if you want to just see how on the one side, all of us, like everybody in administrative law, everybody dealing with human rights, will clearly say that the system is not working. However, one of the avenues of remedy has now been denied. So the only solution now is to actually mandate timelines in a statutory way. And again, once you do that, you have to recognize that we have limited resources. Any institution, especially the Alberta Human Rights Commission, which was grossly underfunded, has to then just recognize that you have to do what you have to do based on the funding that you have. Otherwise, you're just in like mud, right? So this may cause more efficiencies, which is, I think, the point that both Nam and Bob had pointed out. But at the end of the day, I think it's all of us who have to then view whether or not are we getting closer to meeting our responsibility for Indigenous rights. And I've written several articles on the fact that we've absolutely done nothing in Alberta for Indigenous rights. Nothing, like absolutely nothing. I was adamant about this when I was at the commission, that we are not doing anything. Where our funding, our are the cases that we took on, whether there was a test case, we didn't do anything that would even be remotely interesting in that area. And so if you know the history of Alberta human rights, we do take on these test cases. And so like for something like Aryan Nations, I think there was such an amazing merging of so many people that were really focusing on the discrimination against people of Jewish faith, and everybody came together, and that you got a really strong decision out of that. But like, for example, when the first issue started, when the actual commission started looking at sexual orientation, they actually shut the commission down. So do you see that in one case, one gets support, maybe because more politically it was more acceptable, but then the other one about sexual orientation actually shut the commission down, and then we had to reinvent it. So and I know that Bob did a conference just this weekend or last weekend with Ron Gitter, who was actually responsible for the rethink after the government shut down the commission. So again, and that's happened time and time again, where the politics of Alberta will then interfere with trying to get toward equality or looking at systemic discrimination. I'm happy to kind of say two things about efficiency. One, it's a necessity when we're dealing with limited resources. And then two, when you want to then move forward, if you are going to then give more power to one statutory player like the director, I think you have to add, and I've always advocated for this, more participation at the front level for those, even public and private actors. This is something that I think is missing from these amendments, is that level of participation, giving access, even at the earlier stages, so people, even though we know the system takes a long time, we do want as many people involved. So I guess all I would say is that if these amendments are just a first step, that's fine, but then resources have to be put into, and policy has to be put into, to give more grants, to give more access at the preliminary stages to public and private actors, so that there's more participation of those that are victims of human rights abuses.
Well, the first impact for me, which is why I even talk about this, is that I had two complaints from two clients tossed out. So, because according to the director, there was no reasonable prospect of success. So, and like I said, so before the amendments, complainants were already struggling with providing evidence. Most discrimination that happens at work would happen within an environment controlled by the employer. So for instance, the employer controls the computers, the work tools, and those tools would contain any evidence that an employee who alleges discrimination might need to prove discrimination. So that was part of the uneven playing field that I alluded to. But like retired Judge Swift mentioned, I think behind this amendment, were two issues. Inventory control. Some of us may recall that prior to the amendments, the Alberta Human Rights Commission had started their case inventory management system for cases filed prior to January 1st, 2019. So it seems to me that that was part of the process to give the director kind of unfettered discretion to toss, complaints that the director thought should not be clogging the process. The other issue, which he also mentioned, is resource availability. Again, it happens to be within the political domain, how much budgetary allocation is given to an agency like the Alberta Human Rights Commission. And again, that depends on where it ranks in government's priority. So I think that those were the two issues from my perspective that drove the amendments. It doesn't seem to me that the potential complainant fared any better after the amendments. If the purpose was actually to ensure more access to justice, then the standard should have been lowered to the arguable case standard. Because in the case that the Court of Appeal gave that legal principle, Miss and Alberta Human Rights Commission, they said it's not as low as an arguable case, but not as high as reasonable prospect of success. So why go for the higher standard if the concern is access? We have lowered the bar so more people would come in.
I can tell you that the commission has and had, and they can rename it all they want. Like, we've had multiple triage processes, and there, you mean, I used to refer to them as levers, right? Like, what lever are we pulling? And it, whenever you want to talk about triage, you also have to understand what is the policy behind that, right? Like, so, like, but I can tell you, like, for example, when there was an issue with medical services and those of the transgendered community, the commission put a lot of resources to make sure that those issues were front and center, and there was a lot of really good use of resources to ensure that there was protection of those that were seeking a remedy, and it was that was a really good triage process. But then another triage process, which is, I think what Nam is talking about, is when you change the standard through which a complainant has to have some sort of level of evidence or some sort of level of information enough to satisfy a statutory decision maker. I think that's dangerous, and I adopt the word that Bob had. That's a very dangerous way to look at triage, right?
It's time, I think, for a wholesale review, both about, do we want to have, for example, and I'll use this term and I'll try to explain it, a direct access model. Many legal disputes are he said, no, he said. A says this, B says that. And very often there are few, if any, independent witnesses. There might be some documentation, but generally it's one person making an allegation and another person saying that allegation is untrue. A direct access model says, you have a complaint, let's go to this tribunal, much like we do in courts. But remember that we're very often dealing with people with few, if any, resources. I mean, most lawyers I know can't afford to hire a lawyer. I mean, it's very, very difficult. Another possibility, and it's been done by statute recently with respect to the transmission of sexually explicit images of a person, the provincial government in a statute created a tort. They said that's a wrongful act. Do we want to do that with human rights and simply say, take it to court, go there? I'm not sure that the courts are the best model, but I did advocate on the weekend that maybe the tribunal, because there's been a great deal of discussion about the lack of independence of the Human Rights Commission, and particularly lately with the appointment of a particular commissioner and then that removal of that commissioner, and now an interim chief. What's wrong with having human rights issues decided by the civil division of the provincial court, because they have some expertise. They do a lot of employment law cases. They are truly independent. I think there's a danger that we can lose our confidence in a system that looks like it's susceptible to government interference. And Armand talked about the Delwyn-Wren case, which is about sexual orientation, and it was an employment law case. Delwyn lost his employment because he identified to his employer that he was gay. That case went all the way to the Supreme Court of Canada, and the Supreme Court of Canada said he is protected under your human rights legislation, even though it wasn't specifically included in the legislation. They read it in, which is a judicial bit of gymnastics when they want to do something that they think is right. But it took 10 years for the government to actually put it in the legislation.
Because again, I think the gatekeeping model is a way to control cases coming in. So it's an inventory control, the first inventory control mechanism actually. If that report, 2020-2021 annual report of the Human Rights Commission also showed that they fielded over 8,000 inquiries, I guess, regarding human rights violations. And out of those 8,000, I think only 3,000 made it as potential complaints. So I think they're using that model, the gatekeeping model, to control the number of complaints that they handle. I suppose that if we adopt the direct access model, the system will be overwhelmed, because even with the gatekeeping model and all the squeeze, to potential complaints, the Human Rights Commission still has a huge backlog. People are complaining that the system is broken, and that doesn't translate to access to justice. I think Rob said is unconscionable, the amount of delay that we witness in the system. Yeah, I think at the end of the day, we have fingers pointing out to resource availability, resource allocation by the government as one of the reasons for what is going on, and perhaps one of the reasons again for the amendments to the Human Rights Act. Thank you.